We'll give you 3 minutes.
Thank you. I should be quick then. My name is Marcus Baldori. I'm representing Mason Data Center Facts. I've heard many of the residents' concerns. I think most people want this ordinance to be protective. I've heard that from the City Council as well. But what is protective? For example, there's a real policy debate as to whether data centers should be use by right versus special use permit. I think a protective measure would be special use permit. There's also other considerations like height, noise thresholds, operational standards. These are core zoning questions, and many think that the current ordinance is not protective enough. I've heard it repeated that without Ordinance 266, a data center could simply move forward under M2 or as an unclassified use. After looking at Michigan zoning law, I don't think that this is entirely accurate. Data centers are not listed in M1 or M2. They don't fit plainly within the language of those districts. An unlisted use becomes a discretionary determination, which is governed by Michigan law. That process is not automatic. In practice, that leads to a special use permit, which requires public notice and hearing, clear and convincing evidence, and it allows the cities to impose different conditions. If there's a different legal pathway under which a data center could proceed under M2 or an unclassified use, I think the public should hear that step by step, clearly and precisely, not as a generalized warning to justify rushing in an ordinance right now. That's not something that residents seem comfortable with. For that reason, I think a 6-month to a year moratorium is totally appropriate. It allows the city to consider more protective measures, and a lot of them have already been suggested, and I know a lot of people will talk about what those might be later on. If the ordinance is adopted, we're prepared to proceed with a referendum petition. It's been submitted already. A draft has been submitted to the city and the city attorney for review. I've got a copy right here. We'd aim to collect 1,000 signatures or more, and I think based on public engagement, that appears to be very realistic. Section 7.12 of the city charter says we need approval as to form by the city attorney before circulating for signature. We've submitted to the city attorney. Now there's some question, well, I can't approve it before it's adopted, and I understand that. But you know, if it's adopted tonight, well, that's my first call in the morning, and it should take an hour to review because it's one page with a few sentences. So this won't take long. It shouldn't take long. And but really, I think just taking more time, there's really no reason to rush this. And again, slowing it down is totally appropriate. There's a lot of ways to make this more protective. And again, I go back to the first example I said, special use permit as opposed to use by right. And again, if there are ways for the a developer can be very creative. I understand that. But we should identify exactly, if we don't adopt an ordinance, what exactly is that process? Because from my standpoint, I don't think that's a straightforward process whatsoever, and the burden should be not on us to explain that process, but on the city. Thank you.